Well, my name is Robert Simu SAN, and I'm the lead counsel for Nafiu Bala, who is the plaintiff at the Federal High Court and the first respondent at the Supreme Court that just delivered judgment in respect of that appeal today.
So in reaction to this judgment just delivered now, and what does this actually mean for those who do not really understand?
Okay, thank you very much for that very, very good question. Now I need to highlight the fact that the appeal that gave rise to today's judgment was predicated on 7 grounds of appeal. 6 of those grounds failed completely. The Supreme Court dismissed them. Now the only ground that succeeded is the ground that dealt with the issue of the consequential order to maintain status quo ante bellum. And the view of the Supreme Court was that the court that can make an order for status quo ante bellum is a court that has proceedings pending before it. And since the Court of Appeal had correctly held that the appeal before it was an incompetent appeal that was a complete abuse of process, there was nothing again pending before the Court of Appeal to which it can engraft an order of status quo ante bellum. That the court that still has proceedings pending before it was the Federal High Court. That is the only court that can make an order for status quo ante bellum, and not the Court of Appeal, because the Court of Appeal correctly held that the appeal filed by Senator David Mark was an incompetent appeal. It was incompetent because it was an appeal against the exercise of judicial discretion by the Federal High Court, and that the Federal High Court correctly exercises discretion by saying, you, defendants, come and show cause why I should not make this order. Come and show cause why I should not make this order. More importantly is that appealing against such an order, you cannot now properly engraft an issue of jurisdiction on it. This was the main decision of the Supreme Court. So the appeal in the main failed. It failed because the real objective of this appeal was to get the Supreme Court to decide the issue of whether or not the claim before the Federal High Court was justiciable. Was it a justiciable claim or was it not? Supreme Court said the Court of Appeal properly declined to hear it because that issue is properly before the Federal High Court. We are going back to the Federal High Court for the case to be heard on the merits, on the basis of the order of the Court of Appeal for accelerated hearing. Let me make the point. The order for accelerated hearing made by the Court of Appeal was not a subject matter of appeal. So nobody challenged that order. So that order is still subsisting. So there's an order for accelerated hearing. So the Federal High Court, go ahead this case and hear it expeditiously and decide it.
So sir, just lastly, for in clear terms here, what do you understand by when the court said that the judgment succeeded in part?
Now I have now explained to you that the judgment succeeded in part only in respect of ground 7. Out of 7 grounds of appeal, 6 failed. They filed 7 grounds of appeal. Grounds 1 to 6 were a complete failure. Supreme Court dismissed them. The ground 7 that succeeded is limited to the narrow issue of the consequential order. Status quo ante bellum. Should the Court of Appeal have made that order? Supreme Court said no. That the only court that can make such an order is the court that still has case pending before it, which is the Federal High Court. So that is the only narrow issue on which this case succeeded. It failed on every other ground.
So does it mean the
that is now for the courts to decide. Are you with me? That is for the court to decide that issue. That issue, that question, the question he just asked, did not arise for decision at all by the Supreme Court. The Supreme Court did not enter into such an issue to decide it. Whether this person is the chairman, whether this person, that issue didn't come up at all. It fell within a very narrow technical compass. Was the Court of Appeal right to decline to hear their appeal? That's all. And Supreme Court said, yes, they were right, but they were wrong to have made that order for status quo ante bellum.
Basis of ante bellum that INEC
removed him, delisted him.
INEC did not remove anybody.
They recognized him.
INEC simply acted on the order of the Court of Appeal. That is what all this.
Understand is now that order of the ante bellum has been vacated. Does that now mean that
You see, let me let me emphasize, because what we are dealing with now is a principle of law. The most fundamental principle of law is that whenever, and I repeat the word, whenever a case is seeking for an injunction that do not do this, do not do that, whether an order is made or not, you act at your own peril if you go ahead to do what is being sought to be restrained. Because if the case succeeds, you are going to do everything you have done will be reversed. That's the effect of it. You act at your peril. This is the decision of the Supreme Court itself. You know, Jukun-Ago State Government. It's an old case, 1986. So this is a firmly established rule of law. Whether an order is made or not, the moment we are aware of an injunction, you have to just simply stop doing what you are doing and respect the authority of the court to decide the case one way or the other.
Please, let's have your full name, sir.
The name is Robert Peril, SAN.
Thank you so much.
Thank you.
Thank you.